Okay, everybody, we're going to go ahead and get started. Again, this is Erin Sullivan, Policy Analyst with the Department of Labor and Industry. Thanks for attending today. This is the Compliance 101 webinar. Again, if you are a task force member and you haven't been promoted to a panelist yet, please raise your hand and we'll get you promoted. And then I am going to go ahead and pass it over to Quinlan O'Connor. He is our Chief Legal Counsel, and he is going to be leading us through the discussion today. Quinlan.
Hi, everybody. Um, my screen, sorry. I, as Aaron said, I'm Quinlan O'Connor. I'm the Chief Legal Officer for the Department of Labor and Industry. This is designed to be sort of a brief overview of the disciplinary process and a touch on non-routines and how those are distinct for the licensing process. I'm happy to take any questions. I will caveat that early on and then throughout with I am not happy to answer questions about currently pending matters or, if you want to file a complaint, great, go for it, file a complaint, but I don't want to talk about those either because there are a bunch of different rights and impacts involved in all of that. So with that caveat in mind, can everybody see the PowerPoint? Can anybody see the PowerPoint?
Yes.
Yes, we do.
Perfect. Thank you. Okay. All right, so brief agenda. We're just going to kind of walk through the lifetime of a licensing complaint. So that's how to file it, how it gets processed and reviewed, what is administrative closure and when does it and does it not apply, what are licensing investigations, what are screening panels and how do they operate, what is due process that's available to licensees, the adjudication panel, and petitions for judicial review. And then, as I say, we'll touch on non-routine applications and how they're the same and different. And there's lots of data throughout this thing. All of that data is up to date as of February 12. So it's pretty recent, but not perfectly up to date as of today. So obviously things change. This is all live data at the end of the day. So with that in mind, how to file a licensing complaint. We tried to make this as simple and straightforward for the public as possible. So licensingcomplaints.mt.gov is the website where you can go to file a complaint. Frankly, if you Google Montana licensing complaint, our website also comes up. There's a bunch of different walkthroughs on that site. There are FAQs to answer some basic questions about what the procedures look like and instructions for how to file the licensing complaint. And at the end of the day, there's just a button that says online licensing complaint form that you can click. That's what you're seeing there on the right. Right below that button on this screen is the real substance of what's on the form. Obviously, we collect some basic details about who you are as a licensing complainant. We need your name and contact information and things like that so that we can ask follow-up questions, so that we can orient the licensee to what the complaint against them is and help them to be able to respond to the complaint. And we have an option to upload documentary evidence as well. And so you can use a zip file. If you've got 100 documents, you can just upload one, whatever you have that you think is helpful or relevant to the complaint, you can file on that form. Anyone can file a licensing complaint for any reason. And that's really the simplest way that all of this starts. You can submit them in hard copy still. We encourage folks to use the online thing. It's easier for them and for us to process those licensing complaints. And it lets the process move forward in as timely a fashion as possible. Okay. I do also want to note, and there are some changes legislatively on this, that licensing complaint filing is protected essentially. So Representative Steve Fitzpatrick brought House Bill 563 last session, which voids any contract that prohibits, discourages, or otherwise bars or purports to bar the filing of a licensing complaint or the cooperation with the licensing investigation. Essentially, you can't enter a settlement agreement, for example, in a malpractice complaint that says also you can't talk to the Board of Medical Examiners about this malpractice complaint. You have to be able to, we protect that right to file. You have to be able to talk to the Board of Medical Examiners. So thing one of that bill is it voids the contract that purports to bar that right. And thing two is it makes it unprofessional conduct for the licensee to enter a contract that says that. Essentially, licensees are in the best place to know that they can't enter these contracts as opposed to somebody who's been harmed by a licensee. And so it's on the licensee to not enter into those contracts. If they do, that is a basis for a complaint as well if the board finds out or if a program finds out we can subject the licensee to discipline for that as well. We also had House Bill 435, which updated unprofessional conduct in a variety of different ways, but the primary one for this purpose today is in 316(1)P, which prohibits a licensee from interfering with an audit, investigation, inspection, disciplinary proceeding directly by failure to respond or cooperate with the investigation, or by use of threats or harassment against a witness to prevent them from providing evidence. So this is really getting back at the same thing, just outside the contract process. If you are trying to retaliate against people because they engaged in the filing of a complaint, you can't do that, and you can be subjected to discipline for that as well. So what does this look like? We are seeing increases year over year over year in occupational licensing complaints. So the graph on the right shows the quarterly filings. There's a lot of variability in what each individual quarter looks like. I have tried to break down this data in all sorts of different ways to see if some week of the year is higher or lower, or if it seems to correlate to anything. As best I can tell, there is no correlation to anything when licensing complaints come in. What we do see is that the complaints are going up year over year. So that black bar that's across each of the years is the average quarterly complaint filing in that year. So you see it was 193 in 22, 226 in 23, and up from there up to 272 per quarter on average last year. The distinction in colors there is licensed complaints versus unlicensed complaints. So if somebody purports to be a dentist and doesn't in fact have a dentistry license, then we get complaints on those as well, and we can pursue various actions against them to stop the unlicensed practice of dentistry or pick any other profession that requires a license. So those complaints come in as well. You see the volume is heavily favoring the licensed side, but we do get our fair share of unlicensed complaints as well. The highest volume boards are probably unsurprisingly behavioral health, Board of Medical Examiners, and nursing. That's just their 2025 numbers, but it's fairly representative. They are always far and away the highest complaint volume boards, and we continue to see those numbers go up. For a bit of perspective, the Board of Behavioral Health in 2018 received 55 complaints, and last year we got 204, and that's been a steady increase between 2018 and the present. So it is just going up across the board, and so the boards are seeing and processing a lot more licensing complaints. So we intake these complaints, we have the complaint, then what? Well, step one is notify the licensee that a complaint has been filed against them. They get notice of the complaint. This is different from sort of a big N notice that I'll talk about in a few minutes. This is literally, we got this complaint. What do you have to say about it? The timeline for getting these to licensees has gone down dramatically. That's the graph on the right. In 2022, when we first started measuring this, we were at 21 days to notify the licensee. In 24 and 25, we were at 5 days to notify the licensee. So we're within a business week to notify the licensees of this. You can see it's down to 3 days in 2026. I wouldn't trust that yet. We're only a few weeks into 2026 as of this data, but we are speeding up the timeline to get licensees notice that a complaint was filed against them. And as I say, what's involved in a notice is broad. You have the opportunity to respond. You are supposed to respond. As I say, it's unprofessional conduct to ignore the licensing boards. And I will say the licensing boards don't particularly appreciate it when they get ignored by a licensee either, as they consider what discipline should happen on a licensing complaint. But it's the licensee's first opportunity to explain their side of the story, set forth additional facts. Certainly, licensees are entitled to counsel in this process at any stage, including at the initial response stage. And so they get that opportunity on the front end to provide that response. There is a category called administrative closure. So there are some complaints that are just fully outside the jurisdiction of the licensing board, but technically complain about a licensee. So the example that the commissioner likes to give that she's heard about is somebody files a complaint against a dentist because the dentist's receptionist was extremely rude to them. It may be that the receptionist was rude to them. It is also not within the jurisdiction of the Board of Dentistry to do anything about that particular issue. And so those cases that are outside the jurisdiction of the board, the department has the authority to administratively close. That is all the department has the authority to administratively close with regard to occupational licensing boards. Programs are a little bit different because the whole process is run through the department. But with boards, everything that could be within the jurisdiction of the board goes to the board. And you see in the graph on the right, the administrative closure numbers are going down in recent years as well. What that functionally means for the boards and board members is that they are seeing and hearing more complaints. These not as many complaints are going away. We're under 100 administrative closures. So of those 1,100 licensing complaints last year, we administratively closed about 100 of them. And so all of the licensing boards had to hear the remaining 1,000 licensing complaints across the 24 occupational licensing boards. There is also a possibility for investigation. So we send it out for a response. We get a response. We don't have a complete picture of what happened. We need more information. And this can range in what it means on a variety of different bases. So this can be everything from we just need additional documentation, or we need the court filings in this state or another state, or the board from another state filings, those sorts of things, all the way up to we have to go do a bunch of interviews with a bunch of people. We can't just leave it to a complainant said and the licensee said. We need to interview the other witnesses who may or may not know anything about the circumstance and see what other information we can put together. These can come up in two primary ways. One is we legal can ask a member of the screening panel for concurrence to do a licensing investigation. If they give that concurrence, then we can open the investigation. Or if we've already presented the case to the screening panel on review of the file can say, we really need more information for this. And so they can table the complaint for an investigation. It'll then go to the investigators to complete whatever needs to be done, and then it'll come back to the screening panel to make a decision about whether to dismiss or find cause on the complaint. And as you can see, there are between 45 and 65 cases per year are sent to investigation. So we get then to what is the screening panel. Each licensing board is split in half. There is a screening panel and there is an adjudication panel. And the statute restricts not who can be on it, but that they can't be on both sides of it. That is, you can't hear a complaint at the screening panel stage and then also hear a complaint at the adjudication panel stage. So those are entirely walled off. And we'll get into what the adjudication panel is designed to accomplish here in a few minutes. But in short, what the screening panel does is what's quoted there in that second bullet: determine whether there is reasonable cause to believe that a licensee has violated a particular statute, rule, or standard justifying disciplinary proceedings. And so the screening panel made up of licensees is supposed to look at the complaints, review everything that's in the file that we've gathered for them, either with investigation or without, and make that decision. Either yes, proceed with discipline, and here's why, here's what's been violated under 37(1)(3)16, or a board administrative rule or something else that applies to the profession, or no, this doesn't really warrant a disciplinary action and therefore dismiss it. The chart on the right there shows the percentage of cases that have a cause finding. This is an incomplete picture, and I've got a few more slides that's going to show why I say it's an incomplete picture. But you'll see in 2022, there was about a 20% cause finding rate, and in 2025, it was a little higher than 6% cause finding rate. So of the 1,100 license complaints last year, not very many of them actually got a cause finding to proceed with disciplinary action. And I should also note that screening panel meetings are closed to the public in their substance. That is, just like any other public board, they open the meeting in public, but then they go immediately into a closed session. And this is because the right of privacy for the licensee outweighs the public's right to know about a complaint until there is a cause finding. And that is the hard change there. So the fact that a complaint was filed is never made public. The fact that we have an investigation is never made public. What becomes public is if the board says, yes, we think there was a violation of a statute, rule, or procedure, and therefore we're issuing a notice. That means that the complaint becomes public at that moment. Prior to that, everything is protected and confidential. This is the timelines to get to screening panel on the left. And so you can see we've done a lot of work over the last few years to improve those timelines. So how many days did it take to get to a screening panel from the complaint filing? So back in 2022, we were at 178 days. And in 2025, we were at 130 days. I wouldn't fully believe the 74 days in 2026 because we're not very far into 2026, but we're trending in the right direction across the board, knocking several months off the timeline to get to a screening panel. This is obviously good for us. We're processing cases faster, but it's also good for licensees who would prefer to have licensing complaints hanging over them for less period of time. And I think, frankly, whether it's a cause finding or a no cause finding, at least you have an answer about which one of those things it is. On the right-hand side is the total number of cases that were presented to a screening panel in those years. So cases sometimes take, cross a calendar year to get to a screening panel, and they don't get presented for a variety of reasons. But you can see, just like the complaint volume is going up, the cases presented to screening panel are going up as well. I should have cut off 2021. Our data is incomplete for that year. And 2026, again, this was February 12 data, so we had 198 cases presented to the screening panel in 2026 as of 6 weeks into the year. So again, we're trying to move cases as quickly as we can. There's a lot of volume here, and we don't want them sitting any longer than necessary. And the timing for issuing notice is also something that we're paying attention to. So as I say, the screening panel finds reasonable cause. How long does it take to get to notice? And we're looking at this here in two different ways. One is by the cause date. So if the board found cause yesterday, how long does it take to get us there? And the other is by the complaint date. So if it came in 6 months ago, how long did it take us to get to notice from that cause finding as well? And again, we're trending in the right directions here. 175 days back in 2021, down to 70 days in 2025, and we're continuing to trend down in 2026. And in the second chart there, 104 down to 39. So we're going in the right direction. We're speeding up the process and getting those notices out. So licensees have a property interest in their license, and you'll hear that for a variety of reasons. But what that constitutionally means is that they have a right to due process. Due process is notice, which, as I say, we're issuing faster now, and an opportunity to be heard. What that really looks like for us is the MAPA process. We'll get into that in a little bit. But how we initiate that process is by service of the notice. This was recently cleaned up by House Bill 276 last session from Representative Gregg, which brought us into the 21st century to at least some extent, which recognizes that electronic service can exist. Prior to this, the only available options were service by process server and service by certified mail. Those don't always work, and frankly, they're not always the most convenient for licensees that move or just check their email a lot more than they check their mailbox. And so this allows, if they consent to it, us to serve the notice by email. If they don't consent to it, we still fall back to the old ways of service, focusing on certified mail. If we do have to hire a process server, the other thing that was changed in this bill is that the licensing board can recoup the costs of the process server. The notion is one of these other two ways really should have worked. And so if you're avoiding service, then the cost should be borne by the licensee rather than by the licensing board. And it really is service of last resort. We're trying the other ways before we get to service by process server. That also aligns the statute with the rules of civil procedure. And so in the rules of civil procedure, you can do a consent to mail service. If you sign that, great. If you don't sign that, but we're given the option to, then you can recoup, the other party can recoup the cost of service. So we're aligning there as well. And so what's happening with cause findings? And this is really the other piece of the story from the cause finding rate going down. What we're finding is that the cause findings are remaining pretty much stagnant. And these graphs look super jagged, and I recognize that. But at the end of the day, the difference of 19 or 20 complaints when we're looking at 1,000 or 1,100 complaints is not very many. It's not particularly significant difference. And so we're pretty stagnant in terms of the number of total cause findings. So what we're seeing is more complaints, but not more meritorious complaints according to the licensing boards. But we're still disciplining about the same number of people year over year with some fluctuation between them, but not particularly significant. If there is a cause finding, of course, you can either settle the case or you can request a contested case hearing, and that's what's being shown in the graph on the right. So our number of hearing requests are also remaining pretty stagnant, which makes sense. If we're disciplining the same number of people, the same number of people are likely going to request hearings on that as well. And it's about a quarter of the time that somebody requests a hearing. That doesn't mean it doesn't settle out at the end of the day, but it does mean that they wanted either more time to negotiate a settlement, or they thought they wanted a contested case hearing and change their mind down the road. And so, back to where I said a couple of slides ago, these hearings are governed by the Montana Administrative Procedure Act in Title II, Chapter 4. That's referred to in our statutes as well. What does that mean? It means that it looks a lot like a trial, except it takes place in front of an administrative hearings judge. Parties have the right to call and cross-examine witnesses, issue subpoenas, present evidence, do whatever, engage in discovery, all the things that they need to do to prove their case, disprove our case, however you want to look at it. And they present that to an ALJ. The Office of Administrative Hearings is housed at DLI, but it is fully walled off. I have no oversight roles or responsibilities with OAH. Licensing has no oversight roles or responsibilities. It is a truly neutral office we lose there too, just like everybody else. Those cases get presented there. It is a neutral process, and they issue a proposed finding of fact and conclusion of law. Which brings us to the adjudication panel. So as I say, the other half of the licensing board that is not on the screening panel is on the adjudication panel. The adjudication panel is supposed to be a neutral body. That is, what they are presented when they hear a case is solely the the contested case record, what was presented at the Office of Administrative Hearings, what evidence was accepted into that record, and what briefs were submitted there. Those issues, not everything else that might exist in the world, but they're now restricted by the rules of evidence. And that's why you can't sit on both the screening panel and the adjudication panel. Lots of stuff gets considered by a screening panel, and there can be good reasons for it to be considered by a screening panel, but that doesn't mean that the rules of evidence allow it to be considered. There's no witness to explain what the evidence is, for example, and so we can't put in the foundation so that the evidence can be considered. And so the AP is restricted just to what was accepted by the Office of Administrative Hearings. As I said, the vast majority of cases result in a stipulation or a settlement agreement. The chart on the right there shows the number of cases that were settled prior to actually doing the contested case hearing. So that they may have requested a hearing, but it was still settled prior to the hearing taking place. And you can see, 104 to 150 across those years. The blue bar at the top is the number that weren't resolved that way. But so then you can see, a number of those 40 cases that requested hearing still dropped off by result of a settlement agreement. And then again, we're looking at timing across the board, and happily, the timing is getting shorter for all of these things. And so the total time to complete a case from a cause finding to the final order by the adjudication panel has gone from 230 days in 22 down to 122 days in 25. And so we're taking that down from 9 months down to 3 or 4 months on average. Obviously, there are exceptions to all of these things, but we are, getting in a better way. As I do note there, the 2025 numbers don't fully trust them. The fact that a cause finding was issued in 2025 doesn't necessarily mean that the case has been resolved yet. We're still early in 2026. And again, this data is about a month old, so even more so. But again, we're trending in the right direction. We're doing big decreases year over year in how long on average it takes to resolve these cases. And so the adjudication panel issues the final agency decision, which is a MAPA term of art. That means that is the last thing that the agency has to do with the case from a neutral perspective. And so they issue that decision, and that's what triggers the right to appeal to a district court and from there to the Supreme Court. Once that final agency decision goes, you've got the MAPA timeline. I think it's 30 days to appeal to district court. There can then be briefing on the petition for judicial review there. And then you've got another period of time to appeal to the Supreme Court if you're still unhappy with the decision, or for that matter, we're still unhappy with the decision. And the parties to that are the department as the prosecution function and the licensee. The licensing boards aren't party to that, but we're obviously looking out for what the board wanted to do with their discipline and trying to support that to the extent that it's feasible. And as it says here, we don't get a lot of petitions for judicial review. It's 1 to 2 per year. So we've gone all the way from the 1,100 licensing complaints down to 2 that go all the way up to a petition for judicial review. So that's sort of the end of that process. Somewhat different, but mostly the same as the non-routine application process. So this was another Representative Etchart bill, House Bill 414, which revised how non-routines look. Non-routines, as I think Kevin mentioned last week, are those applications that don't clearly just check all the boxes. There's an issue or there's something missing. There's something that the board needs to specifically review. Those historically were reviewed by the full board. They had a right of contested case hearing, and then they would come back to the full board. Last session, we looked at these numbers and said, we should really be presenting these in the same way as disciplinary cases because they functionally are. And I'll show you some statistics here in a second. But the vast majority of the issues that are being dealt with in these cases are disciplinary issues. It's discipline in another state, it's criminal conduct, it's something along those lines that the screening panels hear all the time. That's what they exist to do. And so we're following that process as of October as well. The due process rights for this are nearly identical. That is, it goes to the Office of Administrative Hearings. You have the right to contest. It goes back to the adjudication panel, all of those sorts of things, with one primary distinction, which is that if the screening panel says grant the license, that's the end. It doesn't have to go to the adjudication panel. It doesn't have to go anywhere else. If the screening panel restricts a license or denies a license and there is no appeal of that restriction or denial by the licensee, then that's the end. Whatever they ordered is the answer. So if they say, do the following 5 things and you're on probation for a year and there's no contest of that, or the licensee says, you know what, that's reasonable, let's do that, we can just issue that as the final order and it doesn't need to proceed anywhere else. By contrast, a disciplinary case, if the screening panel finds cause, it always has to go to the adjudication panel. There aren't exceptions to that process. And so this is a little bit different, but just on that, because having multiple meetings to accomplish the same thing didn't make sense. And here's our numbers with regard to non-routine applications. And there are a couple of different pieces to this, but a primary one, again, at the last session was House Bill 246 by Representative Buttry, dealing with substantial equivalency. And this bill did a couple of different things, but the primary one was that it defined what substantial equivalency was. But it's looking to the education, examination, and experience requirements from the applicant state at the time of their application to Montana. And if it's substantially equivalent, which doesn't mean equal, it doesn't mean more than, it means substantially equivalent to ours, then that is substantially equivalent. The boards, as we've talked about in some of the subcommittee meetings, have been going through a long and arduous process with their executive officers who prior to that went through a long process of compiling basically a 50-state survey of licensing requirements so that they could adopt big spreadsheets that said this license type in this state is or is not equivalent to Montana so that we can be as fully transparent as possible. With enhanced substantial equivalency, looking more to national standards, adopting more licensing compacts, all of those sorts of things, you can see that our non-routine application volume is dropping off significantly from 260 back in 22 down to 180 last year. We expect it to continue to trend in that direction as we get more clarity for the boards, for us, and for licensees about what is and what isn't substantially equivalent to a Montana application. As we make that process easier and clearer for folks, we think it'll be even fewer non-routine applications. They'll never go away entirely, nor should they. There are always going to be some situations that the boards need to specifically look at. But the downside of a non-routine in terms of timing is you've got to wait for the board meeting to come up. And while screening panels meet more frequently than the full boards, they still don't meet constantly, as opposed to the staff on Kevin's team that is in the office every day reviewing these applications. And if they can grant it as a routine application, that's the fastest way to get a license. But if it needs to be reviewed by a board, there will always be some amount of delay as a result of that. So wherever we can reduce it while protecting standards, we want to be able to do that. And so, as I said, this is the statistics, and I realize this is probably too small really to read of what the categories of non-routine bases are. And so we tracked 5 of them: criminal background, prior discipline, education, impairment, and a practice gap. And so what you can see is education in particular has been dropping off quite a bit since 2022. I mean, we were up above 80 in 22, we're just above 30 in 25. But what's staying relatively static is prior disciplinary action and criminal. So those continue to make up a larger and larger percentage of what our non-routine applications look like. And impairment, frankly, is another thing that fits within the prior discipline and criminal activity category, things that the screening panel is used to looking at, and so they fit there as well. With that, I'm happy to answer any questions that folks have.
Thanks, Quinlan. This is Erin again. So we'll start with the task force members, panelists, and one did come through with the chat from Alan. I don't know if you want to pose that to the whole group or if you want me to read that. If you want to pose it to the whole group, just go ahead and raise your hand. But Quinlan, do you want to call on people or do you want me to?
Sure, and I can just start with Alan's question. The numbers are
Okay.
holding steady, but we're hearing there are more people being licensed. Is it safe to assume the cases per licensee has been dropping? I haven't run this specifically against the licensing volume. I should really do that. I've been thinking about doing that. I haven't gotten there. Um, I think that that is correct. The number of licensees has gone up quite a bit in the last several years. Complaint volume has also gone up quite a bit, but I think that the licensing volume is outpacing what the licensing complaint volume is. I might be wrong, and I'm also bad at math, which has been established in front of the legislature. And so I hesitate to be too strident with that answer, but I think you're correct, Alan. Gail, your hand was up first.
Thank you. You mentioned that the cause finding to complete is about 130, averaging about 135 days. What happens in those days? Is that primarily just giving time for people to meet, provide materials that the committee requests, or what are some of the things that happens there? And then I'm also curious if AI has ever been considered in any way, or if that's such a prominent topic anymore, it seems. That a way to help with reviews?
Sure. Well, I'll start with the first one first, and it's to some extent the simpler answer. A lot of different things happen between cause finding and the adjudication panel. If there's a settlement, quite often the settlement agreements happen quickly. We send out the notices typically with a settlement agreement, and so the party can just say, you know what, this seems reasonable, and I made a mistake, and things happen, so just sign the settlement. And then really what's happening is we're just waiting for the adjudication panel to get scheduled. If there's a contested case hearing, then it's all of the discovery, the due process, those sorts of things that have to take place. The hearing officer has to issue an order, and then the adjudication panel has to get scheduled. I haven't broken out the numbers between cases that were settled and how long they take on average to get to adjudication panel versus those that go to a contested case hearing. Again, I probably should do that. It's just not the thing that we've looked at. We're looking at the overarching numbers primarily at this stage, but lots of different things depending on the circumstances. On the very front end, because I'm not sure which one was the 130 days between the complaint going out in the first place and getting to screening panel, it's again a number of different things. That complaint file gets completed by the compliance specialist. We get the response from the licensee. That needs to be reviewed by counsel. There needs to be research that's done to fully understand the context of the thing. Sometimes there are expert witnesses who are retained at that point. And then again, it can be about scheduling of the screening panel. Some of the screening panels for the high volume boards in particular meet on a regular and fairly frequent basis. Some are scheduled as needed. If the board gets 2 complaints a year or 5 complaints a year, we don't have standing meetings because there's not necessarily something for them to do. And if we happen to just miss the date of their meeting, then we can be another year out before the screening panel is going to meet again. So getting everybody together, making sure we have the quorum of the board is where some of that time gets spent as well.
Thank you. And about the AI, is that
Yeah,
ever?
yeah. That's an interesting and ongoing conversation for us, just like everybody else. The legal office has recently onboarded an AI tool to assist with some research functionality, and it is helpful in that context. In terms of reviewing the complaints, not particularly. At the end of the day, the complaints that we get from members of the public are very much complaints from members of the public. That is, they feel that they were harmed in some way and they want to complain about that to the licensing board because they think something should be done. They don't know, nor should they know, nor do we expect them to know whether or not what they're complaining about is or is not unprofessional conduct. So they file something that alleges a bunch of different things, some of which may be unprofessional conduct, some of which may not be, none of which is couched in the language of unprofessional conduct. We get the response from the licensees who do understand some of that more, but then it's really up to the screening panels to make a decision, using their actual expertise as practitioners themselves to understand whether what happened was or was not unprofessional conduct. That's not a place that I've seen an AI tool that I would be comfortable trusting particularly. Certainly an AI tool could do some summarization of the document, but frankly, we want people who understand all the facts and circumstances process to read everything rather than rely on an AI summarization, which frankly we would then need to go back and check anyway to make sure it was doing what it needed to do. I think AI has a lot of interesting applications and a lot of force multiplier applications. I don't think that this is the particular place for it. Certainly, there are a bunch of places once we're in the litigation process where we can speed that up. Certainly, if we get thousands or tens of thousands of pages of records with a complaint, helping us to cull and summarize and organize those documents is a place that AI can be helpful. But that actual final decision is something that we need humans to make.
Thank you very much.
Sierra?
Hi, thank you. This is Sierra Reesberg with the Behavioral Health Alliance of Montana. I have two questions. One, just to confirm, really, this serves as complaints specific to an individual, correct? Not including complaints about like organizations or the board itself or other ancillary types of complaints?
Yeah, so this is licensing complaints, so just about a licensee themselves. I hesitate to say solely about individuals because there are, pharmacy licenses, some of the entities, construction contractor licensing, which is a program, not a board, represents or licenses more the entity than the individual. But yes, it's about the license itself, not about the board or the department. We do receive some complaints about boards, so we have a whole separate and unrelated process for how the department handles those internally.
Great, thank you. And then, are you able to share a little bit more about what the disciplinary process entails, more about like what the settlement agreement looks like? Really, like what's the outcome of that action?
I'm not sure I fully understand, but let me give it a shot and you clear it up if I missed the point. So licensing boards have a few different options in terms of disciplining a license. Presuming they find cause, then they've got some options for what they can do to discipline. That can range from a censure, which basically just says you did a bad job, you need to do a better job in a public document, all the way up to revocation of the license. So there can be suspensions for a time. There can be indefinite suspensions, for example, while something gets completed. There can be like that, basically. They can also order remedial actions. So there can be monetary fines. There can be orders to engage in further education, those sorts of things. And so the board has discretion across those to do a variety of different things and in accommodation so that they can get what they think is the licensee back to a safe practice or fully out of the practice if they don't think that the licensee can be safe to practice based on the conduct that they engaged in.
Perfect, thank you.
They certainly can consider prior discipline as well. And so if they've been disciplined before, there's something that the board can look at and say, we tried this once, it didn't work, so we need to step up the situation. Or, if there are aggravating or mitigating circumstances, something that makes it worse or less worse, they can consider those as well. So trying to look at the totality of those circumstances. The settlement itself looks a lot like a standard legal settlement agreement. We've been updating those to make them more readable for the public and for licensees. But at the end of the day, the substance of them remains mostly the same, which is primarily about, waiving the right to hearing, agreeing to what the sanction and the remedial actions are going to be, how long those things are going to be effective, if it's something that can or should be date limited, and those sorts of things. So they basically lay out what the facts are, they lay out what the discipline is, and they, have some boilerplate legal language about, you don't get to appeal the settlement that you entered into and those sorts of things.
Awesome. Thank you. I have one question that spurred off of that too. Regarding the outcome of the disciplinary process, is an organization, so say that licensed person works at a behavioral health clinic, and the result of the disciplinary action was suspension, does the organization get notified, or is it up to the licensed individual to let their organization know?
The licensing board does not notify an employer. So it's up to the licensee to notify them. Certainly the licensee can't practice. And so, if you've got a social worker who's been suspended from the practice, for example, they can't go to work and continue to be a social worker because they don't have an active license in place at the time. So that ought to force some conversation with their employer. If it was a lesser discipline, a letter of instruction or a censure or something along those lines, yeah, it's up to the licensee to be aware. In the healthcare space, there is the National Practitioner Data Bank. We report to that just like most other health entities are required to report to that. And so that you can get a notification automated through that. There's something called continuous query with the NPDB. And so then if you've just got the list of people who, as an employer, work for you, you can get notified anytime something changes with their NPDB record. That's fairly broad. That's something that's run through the U.S. Department of Health and Human Services. All states report into it. All the licensing entities report into it. Hospitals are required to report into it. A bunch of other things are required to report into it. And so there could be some notification that way. There isn't on our licensee lookup a way to get a notification currently.
Thank you.
I don't see any other questions. Does anybody have anything?
I think we can probably go to public comment now, Quinlan.
Okay.
So if you're a member of the public and you have a comment or question, you can go ahead and raise your hand, and then we will call on you and allow you to speak. Anyone? No, you got off easy today.
Apparently.
Okay, last call. All right.
All right. Well, thank you all. I don't know, is there, I think I'm it for the agenda today, so I think we're done unless somebody else has something.
No, that is it. So we
All right.
we'll provide a copy of Quinlan's slides on the Licensing Task Force website, as well as a copy of this recording if anybody's interested in viewing it at a later date. So thank you all for attending.